This is Debt Free in 30, where every week we talk to industry experts about debt, money, and personal finance. Here's your host, Doug Hoyes.
We just celebrated Canada's 150th birthday, and this is Debt Free in 30, episode number 150. So to celebrate both of these milestones, I'm bringing back a guest from one of our most popular shows ever. Back in season number 1, show number 33, originally broadcast in April of 2015, my guest was Leigh Taylor, and the topic of that show was smart ways to pay off debt. Even though that show aired more than 2 years ago, it is still downloaded many times each month, and as of today, it is one of the top 3 downloaded shows in the history of this podcast. That tells me that Leigh was a great guest because that show has been shared many times by our listeners. So today, 2 years later, I'm bringing Leigh back for round number 2. Today, I want to ask Leigh about debt and bankruptcy myths. We get a lot of information from the internet, and that information is not always accurate. So today, we're going to dispel the top debt myths that Leigh and I encounter as we help people deal with their debts. So let's get started. Leigh, welcome back to the show. How are you doing today?
We're doing just great, Doug.
Excellent. Well, thanks for being here. So you're talking to me from Winnipeg today, I believe. Tell me a little bit about your company and what you do there.
LC Taylor, as a matter of fact, LC Taylor is 25 years old this year. We operate in Manitoba and Northwestern Ontario. We deal with a broad spectrum of insolvency situations, but we mainly focus on personal insolvency solutions.
So your company is very similar to what we do. We deal with people, actual real people. So what are the issues that you see in, Manitoba now? What are the kind of hot buttons there that you like to talk about?
Well, there's a number of them. The one that comes to mind, of course, is the issue with credit counseling organizations. There's a whole plethora of agencies out there, some purporting to be, some have some official capacity, etc., that purport to deal with personal financial problems. You contact them, and they will go to bat for you to solve your financial problems. A lot of them are available on the internet. Some of them are based out of Florida or someplace down in the States, etc. Not all of them are as upfront with their situation as you might imagine. The difficulty is that they try to give an easy, simple solution to people. We've had a lot of situations where people have spent hundreds of dollars trying to go through them to solve their problems to no effect. They don't have any of the necessary tools at their disposal to solve the problem. And eventually they will come to a licensed insolvency trustee such as ourselves, only to find out that they should have come to us first.
Yeah, and that's something we see a lot here in Ontario. We use the term debt consultants. I mean, you're using the term credit counselors. They're obviously terms that aren't legislatively mandated, so it's not like a Class A mechanic. We all know what that is. So we use the term debt consultants because it covers a very wide range. Obviously, there are credit counselors who are legitimate. The not-for-profit credit counselors. My advice to people is if you can actually go in and meet with them, and if they're not charging you a huge upfront fee, then they are probably much more likely to be legitimate. Would that be how you would help consumers decide who's legitimate and who isn't?
Yes, I think that's probably a good rule of thumb. The problem with credit counselors in general, and again, I'm using sort of a broad definition here, is that, well, put it this way, there's an old adage that if the only tool you have is a hammer, every problem looks like a nail. And credit counselors do a good job within their limited scope of abilities and the tools that they can offer with consolidation loans and these sorts of things. But when you get down to a hardcore financial problem that needs a statutory solution, they don't have it. Not all of them recognize that they don't have it. They don't always refer their clients to licensed insolvency trustees that can put together legally binding proposals or bankruptcies that actually work in some situations.
Yeah, I totally agree with you. I mean, if your wages are being garnished by CRA, by Revenue Canada, then you're going to need something legislative, a consumer proposal or a bankruptcy to deal with it. If you need some budgeting help, then a credit counselor is going to be a fantastic resource for you. So I think that's some good advice to alert people that there are many different solutions out there. And you're right. Obviously, you and I are biased. We're both licensed insolvency trustees. Our hammer, to use your expression, is consumer proposals and bankruptcy. But we are also legally required to explain to people all of their options. So if someone comes in to see you or me and the correct answer is go see a credit counselor, you need some help with budgeting, or you need to get a second mortgage and refinance, then obviously that's what we're going to do. That's the way you operate as well, I assume.
Yes, for sure. We talk to an awful lot of people, and like most licensed insolvency trustees, we give free initial consultations, so it doesn't cost anything to sit down with us. To go over your situation, come up with the various options that are available so that they can decide in what's in their own best interest, not necessarily what's in their creditor's best interest or our best interest, but what's in their best interest. I guess you could say that of all of the people we talk to, and we talk to an awful lot of people, we find solutions other than bankruptcy or proposals for more than half of them. Probably about 12% of the people we talk to end up going bankrupt. So there really is a lot of solutions out there that people can take advantage of.
Yeah, and we're exactly the same way. Of the people who call us, roughly 30% are going to end up filing a consumer proposal or a bankruptcy, which means 70% are going to be referred to someone else who can help them, a tax preparer, refinancing. Maybe they just need budgeting help. Maybe they weren't insolvent. So I think those are valid points. So, okay, we're talking about the services that licensed insolvency trustees provide. Let's get into talking about some of the myths surrounding both debt and bankruptcy. And we talked a little bit about it with credit counselors. They're very good at helping with budgeting and getting you back on track. I think one of the big myths that I see or I think people in general would consider to be the truth is that people who go bankrupt are spendthrifts and can't handle their money. And I mean, I can certainly dispel this myth based on our data here in Ontario. We know from our Joe Debtor study that our clients on average have income that is almost 40% below the median income in Ontario. So do you see the same thing in Manitoba? What are the common reasons that people end up having to file a consumer proposal or a bankruptcy?
The biggest single factor over the years has proven to be true, and that's marriage breakup. The rate of marriage breakup in this country is getting higher and higher, it seems. And it's almost a typical situation. You can see a young couple of kids. They're both working. They've got perhaps a normal amount of consumer debt, credit cards, etc., a house mortgage. If they're just starting out, the mortgage is probably as big as they could afford at the time. And then things don't work out. You end up having a split. You end up with legal fees. You end up with all sorts of acrimonious types of interactions, etc., to the point where now you have two separate families trying to support the kids in their own ways. The expenses get higher. It becomes harder and harder to meet what may have been a reasonable level of credit, and they just can't make it. And it's usually, we find on average of 2.5 years after the financial trauma, the marriage breakup or whatever, that people actually get to the point where they have to seek professional help to solve the problem. But certainly marriage breakup is the biggest one. And the thing sort of closely on the heels of that might be that there is no single factor other than that really contributes to it. People can have a reasonable amount of debt, but they lose their job. There's a death in the family. There's all sorts of innumerable financial traumas that can happen in people's lives. And it's that combination where over a period of time, if you don't do anything about it, it's going to result in requiring a statutory remedy.
Yeah, and I think the key point there is, in a lot of cases, it's just not your fault. And yes, okay, I guess we could debate whether my marriage got into trouble because it was my fault or not, but ultimately things happen, and you are better off getting professional help and dealing with them rather than letting it get worse and worse. And I agree with what you're saying. It is often a couple of years after the event itself, whether it's the marriage breakup or job loss or a medical issue or something, that the debts finally catch up to you. You're able to keep it going for a while. And again, I think that disproves the myth. It's not you spent too much money. It was just things happen. So let me throw another myth at you and get your take on this one. So myth number 2, everyone will know I filed bankruptcy. So, I meet with people all the time. They're worried that if they file a consumer proposal or go bankrupt, everyone will know. And I think there's really 2 parts to this myth: who will know and who needs to know. So let's start with the first part. If you go bankrupt, who will find out that you went bankrupt?
Well, first of all, your creditors will find out. If somebody's taking legal action against you or whatever, the stay of proceedings kicks in. Official notices have to be sent out to those people as well.
Well, so let me just stop you there, because you used 2 big words: creditors and stay of proceedings. So
Okay.
so make it. I know what they mean. I'm pretty sure I know what they mean. But explain in layman's terms, what's a creditor? Like, what's the difference between a creditor and a debtor? And then what's a stay of proceedings?
Okay, a creditor is anybody that you owe money to.
Okay.
So if you got a Visa card and you owe them money and the bankruptcy occurs, one of the things you're going to be doing is producing what's called a statement of affairs. A legal document says, this is who I owe money to. These are all of my assets, all the things I own. And based on that, notices will go out to the creditors, the people you owe money to, telling them that the bankruptcy has occurred and they can no longer sue you. They can no longer contact you to collect the debt. They can't garnish your wages. So they will be notified as well. The notice doesn't normally, on a consumer bankruptcy, summary administration bankruptcy, go into the local papers. No need for that. There are some exceptions, but they're pretty rare. Your neighbors don't know. Your mother isn't necessarily going to find out. But part of that, too, is that nobody really cares that much anymore. When you get in excess of 100,000 bankruptcies a year in Canada, it gets a little tedious to say, well, did my neighbor go bankrupt or whatever? It's privacy is a little overrated in that kind of a situation.
Yeah, everybody knows everything. So we're going to get back to the list of the people who would find out. So the people you owe money to is the obvious one. You mentioned a stay of proceedings then. So just can you put a bow on that as to what that means?
Well, it's an automatic legal procedure. As soon as you file an assignment in bankruptcy, go bankrupt. The Bankruptcy Act says nobody can take any collection practices against you. If the creditor phones you up and starts giving you a hard time, simply say, I went bankrupt. This is my trustee. You can talk to them. And legally, they're not entitled to take any further collection practices against you.
Yeah, and that obviously would apply in a consumer proposal as well. So I always explain it to people as the creditors, the people you owe money to, have to stay away. It's a stay of proceedings. So as a result, once the bankruptcy or the proposal is filed, nobody can be taking you to court, garnishing your wages, anything like that. So, okay, so we know the people you owe money to will find out that you went bankrupt. What about Revenue Canada? Do they find out?
Yes, Revenue Canada is going to know. Notification gets sent to Revenue Canada. Certainly, if you owe Revenue Canada any money, back taxes or whatever, you're going to want that stay of proceedings again. And that's pretty straightforward with Revenue Canada. When you file bankruptcy, the trustee is going to do any income tax returns that are outstanding at the date of bankruptcy and 2 returns in the year that you go bankrupt. So Revenue Canada will get notified of that. And at the end of the first year, you're back on your own with Revenue Canada.
And in the case of a consumer proposal, if I don't owe any money to Revenue Canada, they still find out, but it really doesn't affect anything. I'm still getting my refund in the normal way.
Yes.
And what about my employer?
Well, it's going to depend on your circumstances. If there's a garnishment order outstanding, then of course your employer is going to find out about it because we'll send the notice to them so they stop taking the money off your check. If there is no garnishment order, there's no other reason that the employer has to find out about it particularly, then your employer may never know. A lot of times, though, we find that employers are referring people over to us. Yeah. They get the garnishment notice. They don't want their employees working to pay off some court order. They want their employees to be able to to get by just fine on their wages. So it's not unusual for employers to send them to us to solve the problem.
Yeah, and in most cases, the employer's happy that you've taken action, because the payroll person, it's a nuisance for them to have to be, doing the garnishment off your paycheck, sending it off. They're happy to say, great, we don't have to worry about this anymore. It's simpler for the employer, and obviously it's better for the employee as well. So final point on this then, credit bureaus, obviously they find out about a consumer proposal or a bankruptcy.
Yeah, they'll get the information directly from the superintendent of bankruptcy's office. So it goes directly onto their files. That's a lot of people, one of the first things they ask is this going to affect my credit rating? I'm not sure that people understand exactly what a credit rating is, other than they've been taught over the years that it's a good idea to have a good credit rating and a bad idea to have a bad one. Not really understanding the difference. But it's not that bankruptcy hurts your credit rating, strangely as that sounds. Your credit rating's already in the ditch. If you've got a whole bunch of credit cards and people suing you, and all of these people are going to be reporting to whatever credit agency they're reporting to, your credit rating's already off track. Nobody's likely to loan you a lot of money based on your credit rating because it's so bad. What bankruptcy actually does is improves your credit rating, because it puts a stop date on collections. And it simply says, once you're discharged from bankruptcy, those debts are discharged. There's some exceptions, but we're talking generalities now. Rebuilding it.
So let's talk about the rebuilding it then, because myth number 3 that people are totally worried about is, well, if I go bankrupt or file a consumer proposal, it's going to ruin my credit forever. So what you're saying is the consumer proposal or bankruptcy puts a stop to the debts. How long is my credit impacted then? Is it forever, or is it for a period of time? How does that work?
Well, generally speaking, once you're discharged from bankruptcy, that's key. The credit reporting agency will report the fact of bankruptcy for 6 years after you're discharged, which means that you can start rebuilding it. People are going to know you went bankrupt. But going bankrupt is one of the first steps to rebuilding your credit. It puts a stop to the old debts. All the creditors know that. And if you understand that your credit rating is merely a gauge that creditors, lenders will use to judge how much of a risk are you. If we loan this guy or give him a credit card or whatever, is he simply going to run it up and go bankrupt again or whatever? So it simply says that now you've got rid of your old debts, how long is it going to take to get back? And you can start rebuilding your credit right away. There's things you can do. You can get secured credit cards, for example. There's administrative costs involved in that, but nevertheless, that's a handy way to start rebuilding the credit. You can start dealing with rather general Visa or general credit cards. If you need loans or whatever, then talk to your local branch of a bank or credit union where you can talk to a real person, get an idea of what your situation is, show them that you've been able to keep track of your expenses. You're not going to fall into the same trap you fell into before, and build up your credibility. And you build it up with the lender in conjunction with the credit bureau.
Yeah, by paying your bills on time and so on. And I think you made a key point there, and that is, if you're considering filing a consumer proposal or a bankruptcy, the phrase you used was your credit is already in the ditch, meaning you've already got bad credit. So saying, oh, I'd really like to preserve my credit, I don't want to go bankrupt. Well, wait a minute, you are already in bad shape. So if you can't go to the bank and refinance all your debts at a lower interest rate, then doing a proposal isn't going to make it any worse. Your credit, as you say, is already in the ditch. So I think you shouldn't be comparing your credit to perfection, because it isn't that. If you're in a situation now where you can't borrow anyways, or the only borrowing you can do is at super high interest rates, then it makes sense to say, okay, let's bring an end to it and get started. So, so credit is not a forever thing. I know one of the other objections to filing a bankruptcy, and that would be our myth number 4, is that if I go bankrupt, I'm going to lose everything. So walk me through that. Is that true? Are you going to lose absolutely everything if you go bankrupt?
No, that's not the case. Now, it's going to vary from province to province, because what the Bankruptcy Act says is that if an asset or a class of assets is exempt under federal or provincial legislation, then it's not part of the bankruptcy estate. And the most common ones are equity in your home. That'll vary from province to province, but most provinces allow some equity in your home. Motor vehicles, under certain circumstances, can be claimed exempt from seizure. What they call tools of the trade. If you're an electrician and you need your screwdrivers and wire cutters, etc., those are going to be exempt from seizure in most provinces. And there's others too, depending upon your particular situation. The other one I want to note, and the one we get asked about more often than not, is am I going to lose my house? Well, if you have a house, and I'm using Winnipeg figures, a house is worth $300,000, which I don't know if you can get one of those in Toronto.
No, you can't. No, you can't.
A $300,000 house with a $280,000 mortgage against it. Well, the reality of it is that there's no equity in the house. If you can keep up and afford to keep the house, mortgage payments, etc., then the trustee's not going to be interested in the house. We get it appraised, look at the mortgage, not enough equity in there, we can leave it with you. So in most cases, that's the scenario we're looking at. It's not too often we come across situations where they have a $300,000 or $400,000 house with a $80,000 mortgage. Well, the solution is not bankruptcy in most cases. You can refinance, file a proposal, do a sort of a consolidation workout rather than a statutory remedy. So no, it's everyone is an individual situation. So it's a problem when you generalize too much in this area. But the answer to that myth is no. And the detailed answer is talk to a licensed insolvency trustee in your area and find out just what assets are or not part of a bankruptcy situation.
Yeah, and I think that's a good idea because, I mean, you mentioned cars, for example, and it's true in Ontario we have a similar law that a car worth up to a certain amount is exempt from seizure, but how do you determine what the value of the car is? What happens if there's a loan against the car? What happens if it leases? There's always complications that will make it more complicated. Well, no problem. That's something we deal with every day. Obviously, you deal with it every day. So that's why we encourage people, come on in. Let's take a look at your car documents. Let's take a look at the loan documents. Same with your house, your mortgage, whatever. We can then do some digging and figure out what exactly will happen. It's the same with RSPs. RSPs are generally exempt from seizure, meaning we're not going to take them. The only obvious exception is any money you've put in the last 12 months. But again, what does that mean? How is the 12 months figured out? Bring your paperwork in. We can take a look at it and come up with a very specific answer for you. So let me throw myth number 5 at you then, and this is the last one we're going to talk about today, and that is that government debts are not included in a bankruptcy. In other words, a bankruptcy or a consumer proposal doesn't get rid of government debt. So tell me what happens if you owe money to the government and either go bankrupt or file a consumer proposal. Let's start with the simple example, which would be income taxes.
Income taxes are reasonably simple. You're correct. They are part of the bankruptcy. Revenue Canada will file their claim, etc., and be a creditor like any other creditor, and get paid something maybe out of the bankruptcy along with the other creditors. One of the reasons that the trustee will file what we call a pre-bankruptcy and a post-bankruptcy tax return. That means we'll file a tax return from January 1st of the year. So if you went bankrupt today, it would be from January 1st to June 9th. Mm-hmm. And what that does is finds out, is there a refund there? Because the refund is a debt that is owed to you and goes to your trustee. Or if you owe taxes based on that short period of time, we prorate all the exemptions and everything else, so that it sort of gets you on track. If you owe Revenue Canada money, it's caught up in the bankruptcy. We file a post-bankruptcy tax return going from the date of bankruptcy to the end of the year, so that we can get you back on track, if you will. Now, if you owe money and don't make the proper deductions during bankruptcy, you could be faced with paying money back at that point in time. And if there's a refund, it goes to the trustee.
Yeah, and obviously, if you owe money and don't go bankrupt, you're paying taxes anyway, so that's no different. But your basic point is, if you go bankrupt, any taxes you owe up to the date of bankruptcy are included in the bankruptcy.
Yes,
it's
now, there's a lot of other kinds of government debts are involved, but they all fall into the same sort of general category. You do get some situations where EI overpayments, maybe as a result of fraud or misrepresentation, that you didn't fill out the cards properly or something, and you can have a problem with those debts sticking around. You don't see much of that anymore. used to be a common occurrence, but we haven't seen too much of that anymore. But generally speaking, yeah, just because it's the government doesn't make it any different than other creditors in a bankruptcy.
What about student loans?
Well, student loans are a really interesting twist over the number of years, if you understand how they came about and everything. The bottom line right now is that if you go bankrupt and within 7 years prior you ceased to be a student, then that is going to be accepted from the discharge and can be dealt with separately. And there's special rules dealing with it. If it's 5 years old, then you can apply to have it included. If it's more than 7 years old, then it's automatically included. Now, there's been the odd court case in different jurisdictions that deal with how do you measure the 7 years? I think the latest one comes out and says basically it's 7 years from the term or the studies that you borrowed the money to do.
Yep. Yeah. And again, that's a classic example of, okay, don't believe what you read on the internet. Come in, bring your student loan documents. We can give you the phone number to call either the provincial or the federal student loans, depending on who you're dealing with, and figure out what the correct answer is. So last question related to this myth: what debts do not go away in a bankruptcy? So we talked about student loans that are less than 7 years old. Are there any other obvious ones that, yeah, if you owe that, you're still going to have to pay?
Okay, there's just a few of them, if you want generally honest them. Fines or penalties imposed by the court. So if you have a speeding ticket or impaired driving charge or something of that nature, it's not going to be discharged, and they can continue to deal with it, notwithstanding the bankruptcy. Alimony, maintenance, or child support, past, present, or future, is not going to be affected by bankruptcy. So that continues on. Which means that maintenance enforcement could continue to collect if they're responsible for collecting on those kinds of a debt. So you want to make sure that's taken care of. As well, any debt which arose as a result of fraud, embezzlement, or fraudulent misrepresentation of any sort is considered non-dischargeable as well. And that you get into legalese when you talk about that, because what is misrepresentation and these sorts of things? And you may want to talk to a lawyer to get into that definition, because that can get pretty complicated. And other than student loans, you talk about things like intentional injury claims. And other than that, all the debts are going to be affected in bankruptcy.
Yeah, the main one you mentioned would be child support. You're still paying that whether you're bankrupt or not, whether you're in a consumer proposal or not, it's not going to affect it. So, okay, so I think we went through 5 myths there, and I think we've helped dispel them. So to close the show, Leigh, are there any pieces of advice that you would give someone who is listening to this? I guess the one obvious piece of advice you just gave us was, when you've got these kind of issues, make sure you're talking to an expert, not somebody who just is a debt consultant and just started in business yesterday, but an actual licensed insolvency trustee. Is there anything else other than that you would be giving people as general advice?
I think the best advice that I can give to anybody is that when you start to recognize that you're having financial difficulty, do something about it. Don't sit back. I think we mentioned earlier that it's 2 or 2.5 years after a traumatic financial event that people start actually trying to do something about it. If they start earlier, then first of all, they can correct the problem. They can get some good advice. They can talk to a licensed insolvency trustee, get an assessment of the situation, what caused it. They can correct it. And it gives a lot more options, a lot more things that they can do to solve the problem. It doesn't necessarily have to be that, well, bankruptcy is the only solution. You wait long enough, that's what's going to happen. So early recognition, do something early about it, and chances are you're going to come out better.
Excellent. Well, I think that's a great way to end it, and I think that's great advice. I mean, if you've got a medical problem, you do the same thing, right? I'm going to go talk to a doctor right away. I'm not going to wait till it becomes more severe. So how can people track you down? So if someone is listening to us, you've got an office in Winnipeg. You've also got an office in Kenora, Ontario, which is kind of the northwestern corner of Ontario. What's the best place to reach you? What's your website? How can people find you?
Okay, if they just Google LC Taylor, they're going to come up with it. So I think that's probably the best idea. They can contact by phone. The number in Winnipeg is 204-925-6400. And they can email us at lctaylor@lctaylor.net. And if you just have general questions,
Yeah, give you guys a call. Well, what we'll do in the show notes is put up links to all that, and it's literally LC, the letter L, the letter C, Taylor is the name of your firm. So, Leigh, thanks very much. I appreciate you being here today.
Always a pleasure, Doug.
Thanks very much. Well, that's our show for today. Full show notes, including a full transcript and links to Leigh's website, can be found at hoyes.com. That's HOYES.com. As I said, that's our show for today. Thanks for listening. Until next week, I'm Doug Hoyes. That was Debt Free in 30.